For Barrera on behalf of the California Chamber of Commerce, and we are opposed to SB 654 and still have it identified as a job killer. Senator Jackson mentioned in the beginning that she had been working with us, and we did have several meetings to talk about the substance of the bill and ways to mitigate the impact on small employers, because this bill is directly targeted at small employers that have less than 50 employees. As she mentioned, anybody with 50 employees or more are already covered by federal and state law under the California Family Rights Act and Federal Family Medical Leave Act. Because we're directly impacting small employers who don't have a dedicated HR department or a dedicated legal department to navigate the labor laws of California and decide how to implement this, we requested multiple amendments to try and deal with the impact that this is going to create to those small employers. One of them was the employee threshold. This bill isn't applicable to just 20 employees at one work site. It's 20 employees within a 75-mile radius. So you could have 5 employees at one location, 10 employees at another location, 10 employees at another location, and you aggregate those numbers together to get to the 20 employees. It's not 20 employees at just one work site. So if you have a 5-employee work site, but you're under a 75-mile radius where the employer can aggregate those numbers together, that work site with only 5 employees has to accommodate for the 6-week leave of absence. And it's a mandated leave of absence. When the employee requests it, you have to provide it regardless of what else is going on in the workforce. So you're at that 5-employee work site, and what if you have another employee out on another existing mandated leave under California law? You don't have the discretion to say, no, I can't do it right now because my workforce just doesn't accommodate for that. Or can we work it out where you take intermittent leave of 2 weeks, which we appreciate that Senator Jackson took that amendment, but they don't get to say no. And it's an automatic right to a protected leave of absence regardless what is going on with the employer workforce. We requested 25 employees at one location to try and create the balance that was initially discussed and determined when the CFRA, the California Family Rights Act, and Federal Family Medical Leave Act was adopted. They adopted the 50-employee threshold to try and balance the need for the benefit with the need of the workforce. We requested 25 employees at the same location to try and create that same balance. Will it still be a hardship for small employers with 24 employees or 25 employees? Absolutely. But it creates a better balance than a potential work site with only 5 employees or only 10 employees. That was one of the requests we made. It hasn't unfortunately been adopted or a part of this bill. The 6% of employers who will be affected by this, I know where that data comes from. It's from the EDD website, and it talks about per establishment. So I don't know if it's talking about per location or an employer with the aggregate numbers throughout the state of California. But even if it is just per employer, 6%, that's approximately 90,000 employers that are going to be impacted by this proposal. That's a lot of employers in the state of California. Those are the same employers that are going to be impacted at the same time with the increase in minimum wage. Those are the same employers that are already struggling with the paid sick leave mandate that was adopted a couple of years ago. And you continue to layer these burdens on top of small employers, and there's a reason why they can't continue to grow in the state of California. It's a concern. I'm not going to debate the societal benefits. I'm sure there's a lot of studies out there that say parental involvement for the first 5 years of a child's life is important. I totally agree with that. But to say that our small employers aren't already providing that benefit without the mandate is simply unfair. I worked for a small employer when I had both of my kids. There was only 6 employees, and they accommodated my schedule because they value their employees. They didn't need a state mandate with the threat of a private right of action if they didn't implement it perfectly. The other comment I wanted to make is that California already provides up to 4 months of pregnancy disability leave for an employee who has been disabled by a medical condition related to pregnancy. 4 months. This bill would propose that after that 4 months is potentially completed, they would add on another 6 weeks. So now we're talking about 5.5 months that an employer with only 5 employees, 20 employees under this bill, would have to provide for an employee with regards to a pregnancy-related condition. That's an extended amount of time. And again, if they don't bring back the employee to the same exact position they were in before they left, they're subject to a private right of action and litigation. I wanted to talk about the private right of action. We asked, as again a part of our amendment, that before we automatically go to civil litigation with these small employers who don't have a dedicated HR department, who don't have legal resources available to them, why not participate in the mediation program that is currently a part of the Department of Fair Employment and Housing? We even offered for the employer to pay for the mediation so there was no cost to the state. If it can't be worked out in mediation between the parties, then of course go to civil litigation and deal with it. But at least give the small employer a chance to resolve the dispute before they incur litigation costs. From our perspective, that takes care of the costs that employers could potentially face. There was a recent study that came out this year that said a lawsuit under the Fair Employment and Housing Act Average cost is $125,000 to the employer. That's a significant amount of money for these small employers to deal with. And in last year, when the DFEH came out with their annual report, there was over 4,000 cases filed under the California Family Rights Act. 4,000 cases, and these are against large employers who do have a dedicated HR system, who do have a dedicated legal team to deal with their issues, and yet they're still facing over 4,000 potential lawsuits under the existing leave. It indicates the struggle that these employers deal with implementing this leave, and the struggle that we're going to burden small employers with. With regards to those issues, we still remain opposed as a job killer because we do believe this will create a significant impact to our small employers.
Thank you. Please continue.
Mr. Chair, members, Chris McKaylee on behalf of the Civil Justice Association of California. We too oppose the measure. I think our fundamental concern is that Senate Bill 654 adds a new section to the government code under the Fair Employment and Housing Act. And what FEHA provides is the ability for employees to seek compensatory damages, punitive damages, attorney's fees. Quite candidly, when we hear the proponents claim that this bill will affect 16% of the workforce, upwards of 2.7 million Californians, our concern is all the potential litigation that falls under that. What this bill provides right there in the first subdivision, subdivision A, is it shall be an unlawful employment practice to do the following. And that could be failure to provide the leave, failure to provide the return to work to the same or comparable position, failure to maintain benefits, etc. All of those are avenues for litigation. And as Ms. Barrera indicated in that national study, in addition to the average cost through judgment for a business in an employment litigation dispute, they also found in California 40% higher opportunity to be sued, and they pointed to the FEHA statute, and now SB 654 is going to substantially increase those that could derive benefit under the government code. For that reason, we are opposed. Thank you.
Our author had 3 witnesses. We will allow the opposition 3 if you would keep it brief.
I won't take that long. Thank you. Yolanda Benson, representing the California Asian Pacific Chamber of Commerce, representing over 600,000 API businesses, mostly small. I would say 99% of them are 50 employees or less. This would be a very detrimental bill to our businesses. We are part of the economy trying to build more jobs in California. Small employers are not large employers, just smaller. We are family, and we want to take care of our employees. We work hard to do that. And so this bill would mandate the leave that right now our pool is small. We have very few employees as it is. So we would have to figure out how to, first of all, figure out how to cover the duties. Plus, we'd have to try and figure out how to deal with what we may not even know that we are not in compliance with the way that it's written of 20 employees within a 75-mile radius. That could be an auto mechanic. That certainly could be a lot of types of businesses that you, I'm sure, have friends in that are small businesses in your communities. For those reasons, we oppose.
Thank you. Others who wish to speak, if you would just state your name, organization, and your position.
Good afternoon, Mr. Chairman and members of the committee. Javier Gonzalez here on behalf of the California Restaurant Association. We are strongly opposed to